little sweetheart.
They can't do nothing because I tap dance.
This is WVCR 88.3 FM, The Saint. You are listening to Calling Out Controversy, featuring hosts Andrew Hecht and Justin Kenyon.
Hey everybody, welcome to Calling Out Controversy. It's Andrew Hecht as always, and with me is the great
Justin Kenyon.
And yes, he is. So here we are. We are discussing the Seventh Amendment tonight. It is the Seventh Amendment, to be absolutely positive. It definitely is. And
Losing track.
yeah, right. Professor Tom O'Malley will be with us later today. But first, we're going to skip current events because my good friend Eric from back home in Connecticut wanted me and Justin here to cover the storming of Area 51.
It's going to be historic.
So we're going to take a little lighter approach today, a little comedic approach today, see if we can do it justice, because apparently so many people have advocated for storming Area 51 and releasing what they believe is a series of aliens and fictional memorabilia and nostalgic weapons.
The thing I really want to know about it is that how many people who signed up for it are actually serious, and how many are people who are signed up for it just did it as a joke?
Well, I definitely don't think anybody's too serious about it, but
I guarantee you there's some.
there's probably 6 dudes.
Yeah, I guarantee you there's definitely some people in there who are serious about this.
We should actually do an episode on meme culture and how it shapes the modern talking points of the internet and what it does to the minds of people.
Do everything from SpongeBob memes to Simpsons memes and all these other ones, and go how they influence culture.
We should, what we should do? We should get a psychologist on the show and have them analyze meme culture, what's going on in the meme world.
What psychologist would we get?
I don't know who. I'm just saying this would be a good idea for a show. But we got to stick to Area 51 because that's what the listener that asked us to talk, my friend Eric, that's what he wanted us to talk about. That's his talking point. Eric said, and I quote...
Eric, you got your one topic in.
Yeah, no, Eric said, and I quote, "So is your show covering Area 51? And I said, why don't you listen? And he said, all right, I just got iHeartRadio. I'm going to listen to 88.3 FM The Saint. That's a plug, by the way. And I'm very serious. I do have a friend named Eric. He is a very good guy. And him and his girlfriend are listening tonight. No.
I was kind of wondering for a second, does he really have a guy named Eric?
I do have a friend named Eric. Friend named Eric might come on the show now that I've said his name 16 times. This is the longest shout out I've ever done. I shouted out to my coworker Ed very briefly last week. I don't know if he caught it.
I wasn't able to.
No, I try to do shout outs sometimes.
Okay, so what's your full opinion on this topic?
So Area 51, it can go several ways.
Well, do you actually believe there's aliens in there,
No.
the crystal skulls in there from Indiana Jones?
All right, so from what I understand, Area 51 is in Nevada?
I believe so, yeah.
Or is it Roswell?
No, Roswell's in New Mexico.
Roswell
was where the thing crash landed in the Great Depression. That's not Area 51.
So Area 51 and Roswell are not the same place?
No.
Okay, but Area 51 is in Nevada.
I believe so, yeah.
And Roswell's in New Mexico?
Yes.
Okay, so Area 51 is supposed to be where they keep all the aliens, the high-tech stuff, all the conspiracy theories point back to aliens talking Area 51.
The funny thing is, if I was to run something like this, I wouldn't storm Area 51. I would storm Fort Knox and get all that gold.
Well, I mean, gold, yeah, that would be smart. But at the same time, you'd have to split all that gold with the meme lords. And I don't know if you'd want to share your bounty with the meme lords or not.
I mean, hey,
that would
just
trample
like everything
gold
else.
stock.
You hold a good amount. You hold a majority of it. Then you put the minority amount down to the masses.
All right, so
capitalism at its best. It'll be like James Bond.
Well, I mean,
Goldfinger.
thievery.
it'd be like Goldfinger. I'm
Okay.
making a lot of pop culture references for this.
It's the Area 51 episode now.
What
Too bad.
do you actually think any of these celebrities, like Keanu Reeves and Matthew Lillard, the Shaggy, are actually going to show up?
Okay, so so far it's been Chuck Norris, Keanu Reeves, Matthew Lillard, the gang from Lord of the Rings,
Bill Nye,
and
Bill Nye, the false science guy.
no, I mean, listen, he was factual up until a certain point. And
Only 90s kids will remember him being factual.
yeah, only 90s kids remember Bill Nye at his top game. I think that it's being blown way out of proportion. No, I don't think any celebrity is going to go to Area 51 for this, but I am interested.
It's the
let me
meme
try
of
that again.
It's the meme of the month.
I am interested, is what I was trying to say there. I'm interested to see what is going to happen because it, like I was going to say, it can come out into a couple ways. So like, everybody who said they were going to go shows up, including the celebrities. And instead of attacking Area 51, they'd probably just stand out there protesting and then probably turn it into some weird meme festival.
Yeah.
And then that might start a trend of like every year there's a meme festival outside Area 51.
So pretty much like meme Burning Man.
Yeah. That's one option. Second option is you get a few people that show up and they are all very ready to commit a crime. And they try and storm Area 51 and it becomes national news and it's hilarious.
Who here is ready to ruin their lives? I am!
Yeah, right. It would be hilarious if that actually happened. I'm not going to lie. As long as nobody got hurt, too bad.
Nobody got hurt.
Obviously,
That's bad.
worst case scenario, the guards at Area 51 massacre a bunch of people, but that's not going to happen. No way is that an outcome. No way. So, I mean...
I wonder if Trump has been briefed on this.
Probably not. I would argue...
Is it a presidential daily briefing?
I would argue the best you're going to get out of it is probably a bunch of people that show up with signs that say something about aliens and memes and give us the time stone and like...
I also wonder if just like...
What was the thing from Ben 10? The Omnitrix or something?
Something like that. I never watched Ben 10. I was more of a Nickelodeon kid growing up. But the thing is, like, I wonder if just like, if my old track coach and Professor O'Malley, imagine he'd be on an episode where we just talk about Area 51.
Well, hopefully he doesn't get upset that that's what we're talking about before the 7th Amendment. What's important about this episode, Eric, is...
yeah, Eric.
What's important about this episode, Eric, and the listeners, is it's the Summer of Rights.
Especially you, Eric.
And it's the 7th Amendment. And we're talking about the things you should know as an American that actually matter.
Not memes.
But thank you, Eric, for chiming in and being a good listener. And we covered it. We did a solid 8-minute long segment on Area 51. So we're going to take a very early break because we have a very in-depth conversation coming up with Professor Tom O'Malley, and he is going to walk us through the 7th Amendment for the United States Constitution.
Very interesting.
Welcome back to the Summer of Rights, only on Calling Out Controversy, only on WVCR 88.3 FM. Justin, say it.
The Saint.
The Saint. Hey everybody, welcome to Calling Out Controversy. Again, with us today is Tom O'Malley. He is a professor of 4th, 5th, and 6th Amendments at Sage, right?
Yes, at Sage College.
At
yes.
Sage College. And he is also a track coach at CBA. And what else, man?
I'm a trial attorney for 25 years, and I have my own private practice right now, the O'Malley Law Firm. But I used to be a major partner in Mahoney, O'Malley, Nugent, and Alexander for many a year.
All right, and obviously O'Malley being your O'Malley.
Yes, that would be me. Thank you.
All right, perfect, man. So traditionally, you're a Fourth, Fifth, and Sixth Amendment professor.
Yes, I do criminal law. I teach courtroom evidence, and I also teach family law over there at the Sage Colleges, pretty much the Troy campus. But Fourth, Fifth, and Sixth is criminal matters mainly, and it is something that people are usually very interested in. So as far as everyday life issues, you get pulled over by a policeman, DWI, all these type of things,
Right.
Fourth, Fifth, and Sixth becomes pretty important.
Okay, so now we've previously had the Fourth, Fifth, and Sixth episodes consecutively. Before this week, we've talked to Kevin Lewebrand at Lewebrand Law.
I know Kevin very well.
The Fifth Amendment we did on eminent domain and due process, and we showcased testimony from across the country through various video documentaries about cattle ranchers and gold miners. And then the Sixth Amendment, we had Bob Farley come on last week. So this week, you're here to talk about the Seventh. So it's a little bit outside the traditional path that you've been teaching, but I have a feeling you're pretty familiar with it, right?
But yes, very familiar with it. It's one of the probably lesser known of our first 10 amendments for the Bill of Rights, but one that was considered very, very important back in the original days. This was actually brought forth by Thomas Jefferson. He thought this was very important. It was literally written by James Madison. But basically what it does, it allows for, in the federal court system, for people to have the right to a jury trial in civil cases. Sixth Amendment, Fourth, Fifth, and Sixth, they deal mainly with criminal matters. But this was the first time that they introduced civil matters, people having the right to have a jury trial for money damages. And in effect, when they first put it into effect, they said that it was for any case of damages for $20 or more. In effect, now those monetary values are quite higher.
Right. So it kept up with inflation and
yeah. Well,
economic growth.
They wanted it $20 in the beginning to say that, look, anybody that had a problem would have the ability to go to court and have it redressed by a civil jury trial.
Sure.
Nowadays, it's so hard we have courts set up for different monetary amounts. If you want to sue for $5,000 or less, you go to a court, the small courts, the village courts, the small claims courts. If you want to sue in a city court, you can sue for $10,000. If you want to sue in a county court, it's got to be like $25,000 to $50,000. And now to sue in Supreme Courts, it's usually $75,000 or more. The damages have to be. Prior to this amendment, there weren't any basically state courts, and this was only protection under federal courts.
Okay.
But what happened was basically each and every state in the U.S. has adopted some form of the Seventh Amendment, so that pretty much in every state you can sue in state court also for civil damages.
So it seems like a pretty straightforward amendment then. There's not a lot extra into it, or is it?
No. I'm going to read you exactly. It's like one or two sentences. And it just says, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States. Basically, that's it. And it's pretty straightforward. As I said, Thomas Jefferson thought this was one of the more important ones in there because he had mentioned when he drafted his Declaration of Independence that one of the things we wanted to redress was the fact that they were being denied trial by jury under British common law. And it was something that was, very, very upsetting to the colonists, and was one of the major reasons they were claiming that they wanted to separate from Great Britain. So this was something that was very important to a lot of people back in those days, and it's now an essential part of our entire legal system. We wouldn't even think that you wouldn't have a right to sue. If you had a car accident, you wouldn't have a right to sue somebody in
Right.
civil court for damages you suffered as a result of a car accident.
So it also incorporates property damage, then I would assume.
Absolutely covers property damage. It covers. I mean, you can sue for breach of contract
Okay.
in civil claim,
So that's
civil
business
courts.
law, right?
Yeah, so all sorts of business law, all sorts of tort law, medical malpractice, personal injury cases. Someone slips and falls. Someone, as I said before, gets into a car accident. Clearly, these are the types of cases that would fall under the purview. Again, it was this is a federal law, but it has been adopted by all the states.
So does divorce court fall under this type of law? Because it comes under a monetary issue.
It does and it doesn't. The funny thing is, in New York State, divorce court is handled in Supreme Court,
Really?
whereas all the other issues usually arising out of divorce is subsequently handled in family court, but not divorces. Divorces are handled in Supreme Court. There's usually a lot of monetary issues attached to that, so it would be something that would come into a civil trial. And money is a big issue in divorce cases, splitting up the marital property, equitable distribution, child support, maintenance for the husband or the wife, pensions get split. It becomes very much becomes an economic matter in civil court. And clearly, this is one that you can have an issue. Most of your matrimonial cases, however, are usually not decided in front of a jury.
Yeah, I was about
Normally,
to ask that.
they're in front of a judge.
Okay.
But it's a Supreme Court judge, not a family court judge.
So now, under the 7th, it mentions having a trial in front of a jury.
Right.
So is it just the progression of time that we've decided certain cases like divorces where there is an economic issue or a monetary issue that just doesn't need to be in front of a jury, or is it an option? Or
Yeah, the options when we sue in civil court and we are filling out the initial papers, there is a section that says, do you request a trial by jury?
Okay.
There's an additional fee added onto the court course if you do request a trial by jury. Okay. Certain legal issues come up where certain defendants or plaintiffs say, this would be better in front of a judge rather than take a chance in front of a jury. Matrimonial cases, based on the personal nature of everything that's involved, if it's an adultery case or if it's a cruel and inhuman punishment case, they would rather keep it away from a jury who might be very emotionally upset at one party or the other, and therefore a lot of times they want that in front of just a judge. Okay, and the feeling is that the judge is not, that you can't play all the games that you do in front of a jury. You can't do those in front of a judge. They don't buy it, and so you don't waste your time doing it at all.
now, concerning frivolous lawsuits, like obviously the landmark case for frivolous lawsuits turned out not to be so frivolous. That's the McDonald's coffee case.
Yes,
Where the woman suffered
spilled it in a lab.
They
and
suffered
burned.
third-degree burns, yeah. Those fall under the 7th Amendment, don't they?
They fall under the 7th Amendment. Those are civil actions. What people don't understand in a lot of these cases when they hear some of these fact patterns in the beginning, they're like, what? A woman spills coffee on herself and she sues McDonald's? This is crazy. Plus, she had the cup of coffee between her legs when she was driving or whatever. So you would think this is absurd. What led that to being damages awarded to her were other facts that a lot of people don't know about because you haven't read the entire trial transcript. You haven't seen all the other evidence involved. But what that had was they heated it in order to keep their coffee warm, sitting around waiting for people to drive. They superheated it way above what the law was supposed to
It
allow
was something
them.
like 190 degrees.
Yeah, so they would heat it up to some ridiculous amount,
Yeah.
and they weren't supposed to. And that was one of the reasons they said that, had you kept it at the right temperature, then she wouldn't have been so severely burned. So there are other issues that do come up. And in a lot of those cases, there's what we call comparative negligence. And when a jury is trying to figure this out, they look at and say, okay, she was at fault. She was at 50% at fault because she was an idiot for putting the coffee between her legs. Not a smart place to put it. But McDonald's was also 50% at fault because they superheated it and made it to such a degree that it burnt the hell out of it, 3rd-degree burns.
Right.
So what happens is they have a trial. The jury can say 50% liability to each party. The damages to whatever she was, the burns, whatever they say, is $1 million. And then that would mean McDonald's would be responsible for 50% of whatever the jury says the total damages were.
Right.
And that's how they figure it out. So it's comparative. In the older days, we just had regular negligence. And that would mean that if you proved the plaintiff was negligent in any way, the cases you lose.
Yeah.
And McDonald's would win. But now we have comparative, and they say you're 10% at fault, you're with 20, this person was 30. They figure out total damages, and they split it accordingly.
Okay. And that case is also interesting because if I remember correctly, McDonald's was originally only sued for hospital bills.
Right.
And they refused to pay the hospital bills. And that's when they went to court for that $1 million settlement.
Exactly. Had they just paid the medical bills, it would have been 100-something thousand or 200 grand, whatever it was. But then when they didn't bid that, then they went into the lawsuit and they not only asked for the medical costs, they asked for pain and suffering, future pain and suffering, and possibly future medical costs if she had to have a skin graft or whatever else, because it was a serious burn that she had. But yeah, they could have. I mean, we deal with this a lot where we try to settle cases and you ask for a certain amount. And they don't want to do that amount, and then you go to trial, you go through this whole thing, and then a jury gives you 3 times the amount that you were asking for. That does happen sometimes. Other times you go and you could get no cause and lose and not get anything. So it's a gamble that they take, and for the most part, what they look at in the gamble is how much it's going to cost us to try this whole case and pay attorneys and get all the evidence and all this other stuff. Would it be better to just throw them some money and walk away?
So where does mediation and arbitration come in?
Well, in some of the contracts, there are clauses in there that say that you agree not to sue and that you agree to go to arbitration. And normally they have clauses in there that say you have to exhaust, all of your administrative remedies before you can even go to court. And a lot of the businesses like that better. And an administrator could be a retired they'll take in a retired judge and make him an arbitrator, and he'll hear both sides of the case, and he rules on it. And it's quicker, it's cheaper for both sides, money-wise. They usually accept a lot more evidence that you would normally not be able to get into in a regular court of law. They'll listen to witnesses that sometimes you couldn't even get in. They'll listen to some hearsay evidence, things like that, because it's a judge and he knows what is important, what's not important. He can throw out all of the stuff that he thinks is unimportant, and he will look at the facts and he makes a ruling. Usually you get a much more reasonable award of damages when a plaintiff wins, when is a judge. A jury, they sometimes come up with figures that are pretty astronomical at times, according to what part of the state or what part of the country you're in. There was when we were trying a lot of cases, everybody was hoping to get a case in the Bronx. If you had a civil personal injury case in the Bronx, you were getting $1 million, $2 million, $3 million for stubbing your toe almost. These would all be reduced on appeals, which most people don't hear about because they take years afterwards. But the money's given out by people from normally poorer sections. They've been beat on their whole lives. They can't wait to stick it to somebody if they get a chance to. So a lot of times that happens, and you get a much higher verdict. Up in Albany area, it's much more conservative. Upstate, different areas, Plattsburgh out toward Buffalo, the awards are usually less. It's more conservative people that fill the jury.
Okay.
And that's why you get different types of jury verdicts.
All right. That's interesting. So geography definitely comes into play.
Comes in big time. Yeah. Attorneys try to figure out a way of getting jurisdiction in an area that is more favorable to them. And the other side does the same thing too. They don't want it in a certain area. And it's different things that can set up jurisdiction, where the accident occurred, where the plaintiff lives, where the defendant lives. So it could be in different places, and they try to choose. And usually the plaintiff has the first shot at it because they're bringing the lawsuit. So they'll bring it in an area where it might better their chances of winning and getting more money.
So, taking the small claims route,
Mm-hmm.
Obviously America's got I'll call it a fetish. They got a fetish with like court TV.
Oh, yes.
And small claims, and that's when you get your Judge Judy and
Absolutely.
Judge Joe Brown and
Yes.
all these Channel 10 or whatever public access
Exactly.
television channel you guys have. In your opinion, do you think that having those types of shows is detrimental to the court systems, or do you think it's beneficial because it allows for small claims to just get dealt with quickly, and also it contributes to the economy to a degree because people get paid?
It's a great question. Absolutely great question. I think it helps. I really do. Okay, I know people see some of them and they act a little crazy. Everyone's Judge Judy will be screaming back and forth.
Yeah.
But for the most part, what happens is you file a a small claims case. Court of claims is just when you sue New York State. It's a separate court. But because they're all afraid that if you sue the state in a regular court, everybody's going to go after the state. So the state is sued with no jury and only in front of a court of claims judge. It's a whole different scenario. But small claims, first of all, people can see some of the process, because if you go to a regular small claims court, that is the process. They don't really like to have attorneys. They really don't want attorneys representing people in there, although I've been asked, because people don't like to go to court, and they'll ask me to come to small claims. I said, the judge frowns upon having an attorney there. They think it's going to be, the attorneys will be more of a pain in the butt than need be in this matter. And normally in small claims, the judge comes in and it says, okay, you tell me what you think the case is, and then goes to the other side, you tell me what the case is, and then the judge will ask some questions. You might have a witness here or there that you bring in with you, and then they rule on it. And like you said, it makes the system go quicker. If we had to try all the cases that people actually sued on in criminal court or in civil court, the whole system would collapse. So we need to have some fast-type litigation places, which is small claims. And we need to have plea bargains, which is in criminal case. 90% of cases get plea bargain in criminal court. Only 10% or so go to trial. And if you have more than that, the whole system would collapse. It would take too long. And the same with civil cases. You want them to settle. You don't want to go through and use the court system if you don't have to. And the small claims is, for the small claims people, it's important. I mean, they put a roof on their house and they spent $4,000 and water's pouring through and they're upset and they call the guy up and he's like, tough, I'm not doing. It gives them a place to go and tell their grievances to a judge and hopefully get some satisfaction or some money back for it. If you have to go and hire an attorney and pay attorney's fees, and a lot of times attorneys got to get witnesses, and it adds up. The average person kind of doesn't have that. I mean, doesn't have a lot of those funds. So it makes it more accessible to people. It goes quicker. I think when people watch on TV, they do learn a little bit more about it. And if you take away some of the histrionics of the judges who are trying to, make some money in themselves or make a name for themselves, other than that, most of the law they follow is proper law, and I see nothing wrong with them really. I like watching them every once in a while and laughing, but
as a lawyer, do you find some nonsense on those shows in terms of judge decisions or?
Yes, I mean, as far as not only those, but all of the television shows about lawyers in court, most of them, it just doesn't happen. Okay, yeah. The closest to reality was always the originals, Law and Order. If you saw that or you watched that, the last half hour, which normally dealt with the law part of it or the order part of it, I would guess, where they were in the courtroom and stuff, those were very, very, very right on.
The original.
Yeah, well, the Law and Order ones, not the SVU, not the other ones that came out. They were more, again, about the crimes. But in the regular Law and Order ones, the law that was followed, there was actual law. They would cite the actual cases. They would show sometimes they have to appeal, and they would go to Albany and the Court of Appeals or the Appellate Division or wherever they were going to do it. But the courtroom, most of the courtroom stuff is right on, other than the fact that it all takes place in a half hour and ours takes place in a year or two.
Well, that's why they have like the little dates show up right at the bottom of the screen to let you know.
So they try to let you know. But that followed it very well. And, every once in a while, there's things that people don't see that as attorneys are going, oh, he would never let that. One instance would be the person jumps up and says something to the person on stand, and they make them say something they don't want to say, and then they say no further questions, or I withdraw that. And they never show the other attorney getting back up.
Yeah.
Because we would have recross or redirect, and you would get up and say, well, he just asked you this ridiculous question, and they wouldn't let you answer. Why don't you go ahead and answer what you wanted to say? So it doesn't really work that way.
Right, so it builds the drama.
Yeah, on TV it's great, but in a regular courtroom you have an opportunity to rehabilitate that witness and make them say what they want, allow them the opportunity to say what they wanted to say in the first place.
Right.
But Law and Order, I always tell my classes that I teach, and I teach at courtroom evidence, I say, you look at that, the cases they are, and they love it because the things we cover in class, they'll watch Law and Order, and all of a sudden they'll hear an objection, and they'll go, oh my gosh, I know this objection, I know the law, and I know what they're going to say, and it's pretty cool. They enjoy.
That's pretty fun.
Yeah, it is nice to see that.
So continuing with the different types of claims that the seventh umbrellas, what about, I'm trying to figure out how to phrase this. What about like family court you mentioned, right?
Mm-hmm.
But is that covered under the seventh? Because there isn't a monetary thing. It's children.
Family court is a separate court that was set up separately to handle just certain family court cases that relate to families. Also, cases if spousal abuse, things like the separate cases like that,
right.
Child abuse. A lot of those cases can be handled in family court. Kids that are under 15, so a lot, maybe a criminal case,
right? But
they're under 15 or 14. That gets handled also in family court, and there's usually not a lot of money issues involved. The money issues arise only usually out of if there's a maintenance question between maintenance is basically what we call alimony,
child support, all that,
and child support is a big thing. And there's a separate section now of family court that's set apart that handles just child support and not any. So if you have a visitation problem and a child support or a custody issue, and you go down to family court, they'll say, okay, well, the child support issue is going to be in front of magistrate such and such on such and such a day, and your custody and visitation issue is going to be in front of judge such and such on maybe the same day or another day in a different courtroom. So they separate those issues, and they make the monetary one completely economic. And they say that you have one child, and under the Child Support Standard Acts, you have to pay 17% of your gross income minus FICA, and you're not paying it. And they look on the thing, let me see your pay stub, and they figure it out. They got a calculator. They figure out you're supposed to be paying $225 a week. You're paying $110. And boom, they slap them with a new order, and that's how they figure it out. It's all economic.
Yeah, but that's got to be a bit of, well, yeah, I can see a level of inefficiency because you're separating everything piece by piece. But on top of that, child support, if you're making it strictly economic, doesn't account for personal issues that require money.
Exactly. Separate from the child support, that 17% does not count for if the kid has to go to daycare or if the kid has insurance, but there's $200 worth of copays.
Right.
What they do under that monetary issue in family court, they say, okay, we figure out how much your percentage of the total parental income is. The husband makes 100, the wife makes 50. So the husband's 100 is basically 2/3 or 3/4 of what the whole 150,000 together parental income. So they say, well, you have 70% of the parental income. Therefore, any uncovered costs or any daycare costs or any special course with school, they're going away to Disney and they got to chip in money. He has to pay 70% of it, and the spouse would pay 30%, and that's how they split that up.
There's also the issue of in lower income conditions and in lower income circumstances, you have maybe you're living paycheck to paycheck. You can't afford the full amount. Even 17% is a lot if you're dealing with a bit of money.
It's the one thing we see that is absolutely brutal. That's why a lot of people don't like to do family law, because there's not a lot of winners in family law. You have two people. They have two incomes coming into one house, and now they're splitting up.
Yeah.
And they don't have enough money to have two households. They just don't.
Right.
And then one of the households has to pay child support. And we look at it and we go, if he pays the 17% for one child, it goes up to 25% for two, 29% for three, and keeps going up. We go, and he lives at such and such an apartment, he'll have no money to eat. I mean,
right.
There will be nothing. And that's where all of these issues come in. And we have nightmares. We have guys that have kids by several different women, and they have to pay child support. They're never going to get out of the hole, pretty much. And now they've made Schenectady started at first family court. They now say, listen, you pay. Otherwise, if you violate and don't pay the money we say you're supposed to pay, we're sending you to jail for at least a couple of weeks.
Right, but that makes it worse.
They can't work. They can't work while they're in
How
jail.
are you supposed to make money if you're in jail?
They'll suspend their license, their driver's license, and again, some of them need the driver's license to earn money. But the bottom line is a lot of times they do that to just wake them up and say, okay, we're not fooling around. Like, you owe this money. You're hurting the kids. You should have the job, and you should be able to go work at McDonald's if you have to, but you have to pay something to take care of your kids.
Now, in your opinion, wouldn't it be better for the family in general if they were able to come to an agreement outside of the court system then? To say, I can give you this amount of money at this time when I get it, if I can get it that week, knowing that everybody's struggling. Right.
We do come up with ways that the court will waive the Child Support Standard Acts. They'll say stuff like, I'm moving out of the court's jurisdiction, and he won't be able to see the kids as much. So in order to pay him back for that inconvenience, the court will say, okay, we'll allow him to pay less child support, if it's okay with both sides, in order to make up for the fact that he can now only see the kids maybe once a week or once every 2 weeks rather than see them every weekend or every other weekend. So there's ways you can get outside the Child Support Standard Acts, just as the example you just brought up where the family works together. This is the deal we've come up with. We both can afford this. We both agree to this. The kids will be taken care of. The courts will look it over and say, okay, if this is what you both want, and we do deem to be that it is enough for the kids to be taken care of, then we'll go ahead and allow you to be outside the Child Support Standard Acts and not have those hard figures if they're not fully necessary.
So that's within the 7th, but not exactly, right?
Exactly, yeah, because they made up their own separate court for family court. Down in New York City, they have even further courts they make up for just child abuse cases and just spousal abuse cases. It's a separate section of the court that just handles those types of cases.
Yeah, but that's under criminal, isn't it? Because abuse is criminal.
It's a criminal, but it's part of family. Criminal cases can be handled under family court. Again, when you're dealing with spousal abuse, child abuse, or age limits on the kids. So a kid could beat the hell out of somebody, which is absolutely assault second, which would be a felony. But they say that the kid's 14 or 15, we're going to handle this through family court.
That's unless they decide to try him as an adult.
If they try him as an adult, if the crime is so violent that they deem it necessary to try him as an adult, then they can do that. I think the youngest I've seen was there was a Buffalo case where the young boy killed another boy, stuffed rocks down his throat, or some craziness like that. He was like 12 or 13, and they tried him as an adult.
That's insane.
Yeah, but the kid, I guess, had a history of other stuff too. But still, it's a weird thing because even if they're found guilty, they cannot go to a regular prison.
Well, they go to juvenile
family.
detention,
Yeah, they'll
right?
go to these family court juvenile detention centers, and if the sentence is like 10 years, once they hit 18, then they move them to a regular jail for adults. So
So
crazy.
taking another route, then what about intellectual property, copyright infringement, patent laws? All of these come with monetary issues. Do these fall under the 7th Amendment?
Yes,
all of it?
they do.
Yeah?
Breach of contracts, corporate breach of contract cases, intellectual property where they're suing for a lot of money. They all fall under the 7th.
Patent system too?
Yeah, and all of the states have their now own civil court systems that handle all of those types of cases. You get what they have like a note of issue in cases, and in the note of issue it says, is this a matrimonial case? Is this a torts case? Is this a contract? And you go down the line and you sort of check off and let them know. And then it says, are you requesting a trial by jury or just one in front of a judge? Again, some of these corporate cases, they don't want them going in front of a jury. It's such complicated issues, they don't think the jury's even going to understand half these issues. That's why they want a judge who deals, and you get certain judges that all of a sudden will handle a lot of corporate cases on a lot of these types. And there are some intricate issues in these things that I wouldn't be an attorney that would try those cases. I would say, no, you need someone who's dealing with this. This is well over my head. And so they also want judges that know this stuff, because going in front of a jury, they're going to sit there and saying, we got no idea.
Now, what about zoning rates or building permits?
Yeah, building permits. I mean, again, you're going to be in the local zoning board, okay? They rule. That's just the board that's appointed and elected or whatever. And if you lose, then you have a right to appeal. And you can appeal to either the city court on certain zoning matters or the county court normally. And then that's a regular judge will hear those issues. And if you lose there, then you can possibly get to go to the court of the appellate division in New York. We're different in New York than all the other states. All the other states, their highest court is the Supreme Court.
Right.
In New York, the highest court in the state is the Court of Appeals. Our mid-level courts are Supreme Court Appellate Division and then Supreme Court Trial Division. And trials is where we do all of these Seventh Amendment things. Then the appeals go up to the Appellate Division, and then if you lose there, you can possibly be heard by the Court of Appeals. Most states, their Supreme Court is their highest. That's all separate from the federal system, which you have district courts. You go to the appellate level, and then you go to the Supreme Court of the United States. Those are on the federal issues that go there.
So while we're talking about business law a little bit, Bernie Madoff, obviously famous for being the biggest Ponzi scheme ever run in the country.
Yes.
He's tried criminally.
Yes, he did.
Okay. Now, would double jeopardy kick in if he's tried criminally for fraudulent activities and then charged for monetary damages for the exact same activities? Or is it because it's two different amendments, it's two separate issues?
Right.
One's monetary, one's criminal, right?
Yeah, one is criminal, that you found out that he did all of these things. What they do now so that they don't have to have separate trials on that is that during the criminal, they go into such detail. My God, if you have the government coming after you, I mean, when they were doing the Jim Coyne case, remember Jim Coyne from way back when? One of the guys I went to law school with was one of the U.S. attorneys that was handling it. And I went over to go to lunch with him one day, and he brought me up into his room, and we opened up this other room, and it had to be, I don't know, halfway down the hallway, but just full of boxes, all of evidence that they had gotten on Jim Coyne. I mean, you look at that, and you go, oh, my God, who could withstand the scrutiny of this type of investigation? They're going to find out what you did in kindergarten. And it just so happens that when they do these criminal things, they find out all of the monetary things that he's done. And as part of the sentencing, then he has to pay retribution back to all these people they found that he did things to. And they appointed a special, counsel for this. And it's like a bankruptcy trustee. And this guy's job was to go to all the people that Bernie Madoff made money for and determine whether or not they should have known that he was doing things under the table to get them these funds. And
Really?
if they showed that they were, they had to give back all this money they made from Bernie Madoff.
Really?
Yes. And the Wilpons, who own the Mets, were some people that were up there, and they've had money taken back from them because they were good friends with Bernie Madoff, and they're saying that you should have known with your attorneys and with your knowledge of the system, based on what the market was, there was absolutely no way you could have gotten the returns you could have gotten. Something wasn't right, and you should have questioned it, and they didn't. So this guy who's in charge, this trustee appointed by the court on this Bernie Madoff case, and he takes this money back, and they try to give it to the people that Bernie Madoff totally screwed. And, of course, they're never going to get anything back, but they might get back 10, 15% of what they lost.
So here's a question I have about courts, both 6th and 7th, I guess, but we can cover it right now.
Sure.
Since we've done 6th last week. Jury selection.
Yes.
Is it different for criminal courts than it is for civil courts?
Yes, it is. In criminal courts, okay, you have 12 jurors, okay?
Mm-hmm.
And you also pick some alternates, usually like 4. Yeah, my phone is
Oh, okay.
and they have 12. You pick 12 for a jury, okay? And you have different burdens of proof. In a criminal case, your burden of proof is beyond a reasonable doubt. And on a scale of 1 to 100, that's like 90 to 95% sure. Okay? That's how in criminal it works. In civil, you have 6-person juries, okay? And you only need 5 to win. You can win with 5 out of 6. And the burden of proof is so much less. In civil cases, you have 2 different types. You have either clear and convincing evidence, which on a scale of 1 to 100 would be like 75%. And that's for some defamation cases and some other important type of cases, you need 75%. For most of the civil cases, you need 50%. Preponderance of the evidence. Just it's more likely than not they did it. Okay, so on 1 to 100, it would just be like getting 51%. That's all you would need in most civil cases. And again, you only have to have the 6 people, and you only need to get 5. So you can have 5 that say you lose, and 1 says you win. Well, that doesn't matter. As long as you had those 5, you lose.
So how would you feel, in your opinion as a lawyer, of a civil case attribute like preponderance of evidence making its way into a criminal system? Because it seems to me that, like you just said, the burden of proof is at 45% on average less significant than what it would need to be for a regular criminal trial.
Absolutely.
So if you see college campuses, for example, which are not courts of law,
right,
but have decided that through Title IX they want to tackle what is essentially a criminal case,
sure,
in terms of sexual assault,
yes,
right? And they're using preponderance of evidence based fact checking.
Yeah, to me that's, I mean, if you want preponderance of the evidence for just fact checking, just to get it in there, but to make a ruling, to me it has to be at least clear and convincing, and should approach beyond a reasonable doubt. The problem with the criminal matter is that you are giving up a liberty interest. They're taking away your liberty. You're going to be stuck somewhere where you can't leave. Okay, you're going to jail. So that's why they make that a, beyond a reasonable doubt, 90, 95%.
Right.
And in the civil matters, they're saying, well, normally you're talking about money, so is it more likely than not that they did it? So that's where they drop it there. But on those Title IX ones, that's shaky because criminality can come out of that. A lot of times what happens to the kids, they get expelled from the school. I'm not sure if you lose on Title IX here at school, what else do they do other than expel you?
I'm not sure about this particular school, but
right. I know they can expel kids and things like that, and I've seen kids that have been expelled, and they're saying like, look, it's a he said, she said, and I didn't do this, and they don't really have any other evidence, and why am I being expelled? Because I'm supposedly the guy that did something, and again, I'm just using guys and girls interchangeably, but it's a tough issue, and I think what happens is they then turn around and they sue the school.
which then becomes a civil issue.
And then it becomes a civil issue under the 7th, basically. They're going to sue the school saying that you didn't use the proper evidence, you didn't give me these rights, you denied me this right or whatever. And they win a lot of times.
But now here's my big question then, because from the process that you just described, God forbid this happens, but someone's sexually assaulted, for example.
Right.
It goes under a Title IX case instead of going to the police because you're reporting it to your college campus authority and not an actual police authority.
Exactly.
Okay, so instead of a criminal charge being filed, you're then filing a Title IX charge under preponderance of evidence, which is not as concise as a clear and convincing standard or beyond all reasonable doubt standard, forgive me.
Nowhere near it, right?
Right. So now someone's found, let's say, guilty, right? And then they can go and appeal in a civil court for reparations for whatever it costs them, possibly an expulsion, or they have to take that off their school records so they can get into a different school or something like that.
Absolutely.
But the long story short is, meanwhile, if that person actually is guilty, they don't have a criminal day in court where they're convicted of a crime.
No.
So this completely avoids the criminal charge of whatever
stigma,
sexual
right?
assault.
I think that I think, to me, that this should be seconded. I think that if you felt you've been sexually abused, then you should be calling the police and you should start an action there. And that doesn't prevent you from starting a Title IX thing to get them kicked out of the school or something of that nature, because you don't want him on campus. You don't want to see him on campus. You don't want him doing it to somebody else on campus. But there's nothing that precludes them from doing and I don't know why they, again, once it's in the criminal system, there's attorneys that are attacking them, and they, again, we had to come up with all of the special rules for the rape shield laws so that the victim doesn't get. You don't want to try the victim, which they used to do way back when. They would just say, "Oh, she was asking for it. Look at the dresses she wore, all this other crap."
All that negative stuff.
All that negative stuff. So now we had the rape shield stuff, which basically says, look, certain instances you can bring in the history of this victim, but only in certain instances. And they don't allow a lot of it in. But if she's claiming that you gave her a sexually transmitted disease when you attacked her, okay, then you can introduce evidence that she had sex with 5 other guys, the week she says that I attacked them, and any one of those guys might have given it. So you're allowed to bring in some of her background because of that specific issue that she brought up.
Right, but not on a moral character basis.
Right, not on a moral character at all.
But now, because we're dribbling in and out of 6th and 7th, right, but with Title IX now, it just seems insane to a degree that we've taken a court proceeding
and applied civil evidentiary or burdens of proof onto something that was a criminal matter.
But then allowing not even a court to be the judge of it, because it's not even tried in court. It's tried under a tribunal of a college.
Yeah, you have a student tribunal and whatever. Again, I've seen it where people sue. And I think the more these lawsuits come up, the school is going to have to determine whether or not these issues have to be brought in a court of law and stop themselves from trying to be the court of law. Because the bottom line is the school, their real issue is what? Their real issue is to protect
the school.
Yeah. The school itself as a whole.
Yeah.
The student secondarily, but the school as a whole. They don't want, a lot of times, and in the past, they didn't even want these put out anywhere, because they didn't want people to find out, oh, my gosh, Harvard had 5 sexual attacks. Maybe I won't go to Harvard anymore. That type of stuff. It's a bad advertisement for the school. So schools weren't pressing a lot of these things.
Right.
But I think that's why they came up with a lot of these tribunals, to at least give the kids some satisfaction of something being done. But I don't understand, and I guess in some instances the kids don't want to go to the police or whatever, but I think, my advice would be go to the police and do your Title IX. And then the person, if he's found innocent in the criminal courts and he's found guilty under the lesser standard in the thing, well, then he can appeal the school thing, and he can also sue them saying that they violated his rights also.
So one more thing about the 7th Amendment. What to you is the most important attribute, or what is something that you would want the listeners who have been listening this whole time that we haven't covered they should really know, or anything that's just super interesting? Like, what's your key part of the Seventh Amendment?
Well, one thing that they should know is basically because of the Seventh Amendment is why a lot of them have to go to jury duty. Okay.
Okay.
I mean, before this, once this kicked in, everybody had to do jury duty now. I mean, they used to have exemptions like crazy for people, and attorneys wouldn't have to sit on the jury, doctors, police officers, firemen. But the courts finally just said, everybody, we're getting rid of all these exemptions, and everybody has to go to jury duty. Now, I would have been here last week, but I got hit with jury duty. And it was funny, and I told Justin, I said, I can't do it next week because I'm going to jury duty. And I went, the first day you call in, and they said, okay. Because the thing is, you sit there with an attorney going, who would want an attorney on their jury? If I'm helping one side of it, the other side I'm not helping. So
Right.
if I'm like a plaintiff's attorney, or if I'm a criminal attorney and I usually do defense work, then I'm not going to be helping the prosecution usually, vice versa. So why would you really want an attorney on there, And they'll try to start thinking, this guy should do this. But, we all have to serve. In order to make it work, we all have to be ready to serve. So jury duty is the one big thing that came out of the Seventh Amendment, was that now everybody was now that we're allowed for civil trial by jury, we now have to have juries. So we have to be able to commandeer people in order to sit on juries. And so that increased it quite a bit. And it's something that we have to do. And I tell people it's not as bad as they think it is. It's going to a jury thing. And, I didn't have to sit on any, and I get a 6-year exemption now because I went through the process. And that's what they do for everybody. If you don't get on, or if you do get on, you don't get called again. But I think it led to, having your right to be a jury. It's one of the things that a duty that we should have as a citizen, is to be able to do that, to make this court system work and sit on a jury. And it's not as bad as people think.
So we've covered so far family court. We've covered Title IX just now. We covered jury duty.
Mm-hmm.
We covered small claims.
Yes.
We covered claims against people that commit fraud. So difference between criminal proceedings and a civil proceeding.
Yep.
We also covered briefly
breach of contract,
some business law. Then
Exactly.
with intellectual property.
Yes.
We've done, I want to say car accident, right? Damages on property damages.
Yeah, that's I usually covered under tort law, personal
Tort law.
injury, and a personal injury means you've injured someone's self or their property.
Right.
Yeah.
So we've done that.
Yep.
Which also incorporates medical malpractice.
Medical malpractice, is a big
Frivolous
part of that.
lawsuits we did.
Yeah, frivolous lawsuits are tough because there are some that are out there, and you have to be real careful. But I have to tell you, in a lot of the cases, med mal cases, they talk about frivolous lawsuits. I have to tell you, in order to try a case now, the expense, 50, 60, 70 grand they have to put out. So I got to tell you, firms are really pretty strict on whether or not this case is
bringing
because
quality work.
they normally take the hit if they lose, because people aren't going to, the average person can't come up with 50 or 60 grand to
Right.
pay experts and stuff. So, yeah, there are some frivolous cases, and you read about them, and you wonder how in God's name would someone take a case like this. And, I mean, a big one was, I don't know if you remember, the guy who supposedly they lost his pants in a cleaners, and he sued for like $1 million for lost pair of pants. And it went through all of these systems and finally got thrown out, and the judge lambasted the guy.
Yeah.
But it still went pretty far. And some attorney actually took the case.
Right.
How?
How
do
maybe
you
he
sleep
thought he was
at
going to
night?
make his name for himself if he won on pants.
I would think it would be the opposite. Who would take it? You lose your pants, then you can sue for the price of the pants. Okay?
Maybe,
Not $1 million. Give me a break.
But yeah, so it's crazy because when we started the show, the Seventh Amendment, you read the 2.5 sentences that incorporate the Seventh Amendment, but under that, it's a huge mountain of court proceedings and stuff that everyday people take for granted, I think. And it's a
Absolutely.
great episode that we covered here. I think it was very informative. Thank you very much for being on. One more time, this was Tom O'Malley, professor at Sage College in Troy, you said, right?
Yes.
And that's been it. This has been Calling Out Controversy. Don't forget to like and subscribe on YouTube. Don't forget to leave us a comment. Don't forget to email us at callingoutcontroversy@gmail.com. Don't forget to hit up the WVCR website. And if you have any questions, we'll be happy to answer them every week. So you've been listening to me, Andrew Hecht, Tom O'Malley, Justin Kenyon, and this is WVCR 88.3